Please describe the first step in the hearing process.
The first step of the hearing process involves going over the Michigan Open Meetings Act with the parent and the student, at which point I would explain to them that what an open meeting is and what a closed meeting is. An open meeting means that the hearing is open to the public. Anyone who would like could come into the room, they could sit down and hear all of the information. And then under the Freedom of Information Act, if someone were to request information regarding the hearing, everything would be disclosed to that individual. Nothing would be held confidential.
Is this pursuant to a Michigan statute?
Yes, pursuant to the Michigan Open Meetings Act. The closed meeting, the parent may elect to have the meeting in a closed session, the hearing in a closed session, at which time we would post signs on the doors stating that there is a closed meeting in session. A closed meeting is private. The only individuals that will be allowed into the room would be those that have an interest in being there, the school administrator, the hearing officer, a student advocate, and in some cases, security officers are present or a special ed representative. And then if there were others that were allowed into the room, they would be allowed in by way of the parent giving them permission. And then under the Freedom of Information Act, if someone were to request information, only limited information would be shared with that individual, such as the name of the school, what the offense was, and the outcome of the hearing, the decision that was made at the hearing. The next step involves providing the parent with a copy of the hearing packet, which is given to the parent. A copy goes to the administrator or the representatives there from the school. The hearing officer has a packet as well as the student advocate. The difference in each of those packets is merely student name and witnesses' names are not given to the parent. So the parent has a copy that is blackened out to protect the safety of anyone who has written a statement or made statements in regards to the case. The parent is given the packet and has the opportunity to look through that because in most instances they have not seen an incident report. They have only seen the suspension notice and the letters that they've received from the school and from the office that gives them notice of the date and time of the hearing. The name of the student, the date, the time, and the fact that the Michigan Open Meetings Act had been covered with the parent, and they elected to either have it opened or closed. In the instance where the meeting is closed, I would state on the record that I'm moving to have this hearing in a closed session, and that is pursuant to Section 8A of the Michigan Open Meetings Act. Then an introduction is given of each individual that is present, with their title being stated or their role in the district. The next step involves formally stating what the charge is for the record. The name of the school is stated, the student's name is stated, what the school is charging the student with, and what the recommendation for discipline is. And then I would also state whether a Board of Ed policy has been violated or a public act has been violated. In the event that a public act has been violated, I would then cite the public act from the student handbook. The next step is to go over the due process rights with the parent to determine and to ensure that due process has been followed. A series of questions are asked regarding whether or not the student was given written notice by the school. Whether or not the parent was given notice by the school that the student was being suspended and recommended for a long-term or an expulsion. The parent is then asked if they also received a letter from our office indicating the date and the time and location of the student hearing. We verify that attached to that notice of the hearing were copies of the expulsion procedure and what the charges were, and if they received copies of the initial suspension report and the procedures. The final question entails asking if they understand what the charges and recommendations are. In the event that the parent says no, those are explained again. At this point, the parent is told the purpose of the hearing. The purpose of the hearing is to establish whether or not the student engaged in the conduct discharged. And the second purpose is to make a determination, if it is found that the student did engage in the charges, of whether or not to adhered to the recommendation of the school district, of the school. In the event that the school has recommended a long-term suspension and specified a number of days, the hearing officer does reserve the right to make a decision as to whether or not to go with that or to give something less than what the school recommends, and the parent would know that by the time that the hearing is adjourned. The next step would involve, after we've covered those questions and explanation with the parent, the student is asked a series of questions as well to determine that they understand what the recommendation is, what the charges are, and that they understand the purpose of the hearing. Our preliminary questions that are then directed to the administrator as required by federal law. We have to establish whether or not the district had anyone in the district, a teacher or administrator, had previous knowledge of the possibility of the student being eligible for special education services. The administrator is also asked if there had been any reports of a pattern of behavior demonstrated by the student. And in the event that they answer either of those two questions, yes, then we would pause and have a sidebar discussion. We would also like to know if the parent has ever requested an evaluation that has not yet been completed. So again, if yes is answered to either of those questions, we would not continue without having a sidebar discussion with the administrator, the hearing officer, the student advocate. And then a decision is made whether to move forward or to postpone the hearing. In the event that there was a request for special education, sometimes it is necessary to postpone to cover any disabilities and to ensure that there are no disabilities for the student. At this point, the parent is asked if they agree with the responses given by the administrator. If the parent says yes, they agree with the administrator's responses to the questions pertaining to special education, we would proceed with the hearing. In the event that the parent says no, the parent would be asked to explain what it is that they disagree with, and then again a decision is made on how to proceed or whether or not to proceed. In the instance that everything is fine, based on the discussions, the hearing would go forward and a determination would be made regarding the discipline.